My lord, I beg to crave indulgence of my lords. Yesterday, my lord, I made a mention about a student's exam. My lord was pleased to allow me to file it and be listed today. It has been filed, but somehow because some technical error here and there could not be listed. So I am praying, my lord, may this be listed at the end of the board, my lord, because the exam is day after tomorrow, my lord, on 6th, my lord.
Why was it not listed?
Its filing is done, my lord.
The filing has not been done.
You have not filed it.
Oh, no, filing is done already, my lord. This is on the registry, my lord.
It will appear tomorrow.
My lord, the day after tomorrow is the exam.
So you should have been more vigilant in finding it yesterday. Till evening you did not file it.
My lord, I bow down to my lord to that because the order which was also uploaded a little late. That's why, my lord. Although kind enough to, my lord.
No, because of your inaction, the court cannot be activated to do something out of the way.
My lord, the orders were uploaded little late. The order which was impugned.
No, they were all aware of the order. We told them to list the matter. You had filed. Don't put the blame on them.
My lord, I apologize, my lord. Day after, my lord.
Tomorrow,
my lord. Obliged.
From the daily list, item number 1.
Okay. Any short matter is there? Which one? Let me see. Motion. Yes, 3, 4. Mr. Shah, yes?
Ballots.
No, there are matters here also. We are just passing over your appeal for a very short time.
Ballots.
1 and 2 passed over.
Item number 3.
Lordship, there is a review petition on Lordship's order passed on 26/11/24, Lordship. Lordship, in the writ petition, I had stated, Lordship, the review petition under 264 was filed by the
Where is the order of which you seek review?
Lordship at page 9 and 8, annexure A onwards, Lordship.
Our order.
Lordship. Lordship, this last paragraph, we direct the income tax authorities to hear the petitioner, the respondent 9, and other interested parties, if any, and dispose of section 264 application by a recent order within 3 months of the communication of this order. Lordship, I had prayed that I had filed 264 without going through it, and the withdrawal petition was filed by us, Lordship. Withdrawal petition was filed by me to withdraw the review petition, Lordship. Lordship, here in page 11, Lordship, the 3rd paragraph. Now, learned counsel for the petitioner submits as at page 11. Now, the learned counsel of the petitioner submits that her client had no hand in the withdrawal of that application and that it was the handiwork of the respondent and 9. Lordship, this needs to be corrected because I signed the 264 petition without going through, and withdrawal petition was filed by me to withdraw the review petition, Lordship.
Then the assessment remains.
Assessment remains. So, Lordship, may I pray at this stage, let me file a new application under 264 review petition. That may be heard, Lordship. With my undertakings, Lordship. What happened there?
Who's for the department?
Lordship, Income Tax Department. Lordship, I had served. Yes, Lordship, they have a difference. I have already served the copy.
Affidavit of service? file?
Lordship. I have also informed
File the question.
Lordship, I have also informed him yesterday that the matter is coming up today.
Yes, please take down. Yes. This is an application for review of our judgment and order dated 26th November 2024. MSS Parveen, learned advocate appearing for the applicant, submits that the respondents, including the income tax department, has been duly served. Such submission is accepted. Paragraph. It appears that there is a mistake in recording some facts urged by learned counsel in the said judgment and order. Paragraph at pages 4 and 5 of that judgment and order. It has been recorded that the applicant had filed an application under Section 264 of the Income Tax Act 1961 and that without her consent, it was withdrawn by the respondent number 9.
Lordship, yes.
Paragraph. Learned counsel submits that the correct fact as averred in the petition was that the Section 264 application on behalf of her client was filed by the respondent number 9 without permission of the applicant, and that having realized so, the applicant withdrew the application. Paragraph. Paragraph. Considering this mistake and the facts and circumstances of this case, we review our judgment and order dated 26th November 2024 by modifying it to the extent that the applicant shall be at liberty to file a fresh Section 264 application within 3 weeks from date. Paragraph, that application, if filed, would be considered and disposed of in accordance with the directions in the said judgment and order dated 26th November 2024. This application for review is accordingly disposed of.
Highly obliged, Lordship.
Item number 4.
Yes.
Made this lot.
Yes, Mr. Sen?
Sorry, my lord, I could not make it yesterday. Matter was here, your lordships. Only thing, if I can pray, my lord, is this matter taken up on Monday, your lordships? Some problem, my lord, I could not properly go through the briefs.
Lordship, then let the appeal be admitted, Your Lordship. Let it come after vacation.
This is at the admission stage.
Lordship, yes.
What is the nature of the impugned order?
Lordship, what happened, Your Lordship? The respondent writ petitioner herein, Your Lordship, she is a typist. She is a typist, Your Lordship.
Service matter.
Lordship, yes. For promotion, Your Lordship, she has to undergo some sort of selection, Your Lordship.
Now, what is the order passed?
The order, Your Lordship, the order of reversal of the promotion of the respondent herein has been quashed, Your Lordship.
Sorry,
Has been quashed, set aside by the learned single judge, Your Lordship.
what has been quashed?
The order of reversal of the promotion, Your Lordship. She was already promoted, Your Lordship, to the post, Your Lordship. Then on noticing that there was a mistake on the part of the department, Your Lordship, that promotion was withdrawn, Your Lordship. So being aggrieved against that order of reversal, Your Lordship, she filed a writ petition. Then the writ petition was allowed, Your Lordship.
Reversal of promotion was quashed.
Lordship, yes.
And she has retired, my lord. I have received the instruction, just she has retired from service also. So, my lord, I need that instruction also. So, my lord, I don't know.
It is all right, but if we admit and expedite the appeal, don't take steps in contempt.
Lordship, yes.
Yes, this is an appeal from a judgment and order of a learned single judge. In the exercise of his writ jurisdiction. Paragraph, we formally admit the appeal. Paragraph, we expedite hearing of the appeal, dispensing with all formalities. You filed your paper book by 7th February?
Lordship, will do.
Paper book by 7th. List for hearing on 17th.
Lordship.
All right. Till disposal of the appeal, the respondent shall not take any steps alleging violation of the impugned judgment and all.
I'm highly obliged.
From the main list, item number 1.
Is over.
Not weekly list. Daily list or weekly? This is weekly. Weekly list. Which item?
Daily list? Which one?
Weekly. Ask this weekly. Daily. That is why I want to cost daily and weekly.
How many matters are there? No, this hearing matter will be taken up. Weekly list matters, otherwise it will not finish. I'll call them tomorrow. The weekly list will be taken up tomorrow.
Your Lordship, weekly list first matter in weekly list, my Lord, the matter is already pending in Honorable Supreme Court, my Lord. So that matter can await the outcome of the matter pending in the Honorable Supreme Court, my Lord. In weekly list, item 1. So
The same issue.
same issue because the direction was passed by this court to implead the Darbar. That order was challenged by them before the Honorable Supreme Court, and the Honorable Supreme Court on 12th September 2024 has issued notice. So issue is pending, my Lord. That issue has to be decided by the Honorable Supreme Court.
But
first.
these parties are involved, no?
The petitioner, the appellant before your Lordship moved against the order of your Lordship before the Honorable Supreme Court in this same matter.
So why is it appearing in the list?
Because now it was interim order which has been challenged. Final
This is the appeal.
appeal, my Lord. And interim order passed in the appeal is under challenge before the Honorable Supreme Court.
All right. Please take them. The interim order in this appeal is under challenge before the Supreme Court. In that view of the matter, by consent of learned counsel for the parties, we adjourn this appeal till February 12th.
Grateful, my Lord. Obliged.
Yes, call the passed over matter.
I can call item number 1, daily list.
You say, announce there, other matters are released for the day.
Matters from the main list will be released for the day.
I was addressing your lordships on the route to market. Previously, as my lord, your lordships have been told yesterday, the distillers and bottlers would sell to the bonded warehouses, who would in turn sell to the retailers. Bonded warehouses would, my lord, provide the service of, my lord, importing the goods into the state, storing it in the bonded warehouses, then, my lord, providing for payment of the necessary duties, then passing it on to the retailers, who would thereafter pass it on to the consumers. This system was sought to be, my lord, interdicted by, my lord, the amendments to which I have drawn your lordship's attention yesterday, whereby providing that now, my lord, there would be a central bonded warehouse, and it is the central bonded warehouse alone who would have the right to import the liquor into the state. Thereafter, my lord, they would sell it or pass it on to the bonded warehouses, who would thereafter, my lord, pass it on to the retailers. Now, my lord, so far as this is concerned, the first question that, my lord, falls for consideration is, my lord, what was the real requirement of, my lord, this, my lord, introduction of the central bonded warehouse? I've shown your lordship very briefly the response of the government in one of the letters. The second question is, my lord, today, how does it ultimately impact the trade? Now, my lord, the immediate impact, my lord, is twofold. One is the impact on the price, because, my lord, central bonded warehouse is, my lord, going to receive a commission, and that is an acknowledged fact. And that, my lord, that commission is over and above the commission that would originally have been required to be paid to the bonded warehouses. It is not as if the bonded warehouses are done away with, and the services of the bonded warehouse is now to be performed by the central bonded warehouse. Very significantly, the bonded warehouses remain, but now we also have a central bonded warehouse. Now, my lord, the bonded warehouses, my lord, under the scheme, was to receive a, my lord, minimum commission of 8%. That was a fixed commission. It was uniform for all bonded warehouses, uniform for, my lord, ultimately, the importation of all liquor brands by the bonded warehouses. Now we have, my lord, a third entity, my lord, which does not provide any additional service, So, my lord, one wonders why its, my lord, presence was required at all. Secondly, my lord, the question is, my lord, it is saying that I am entitled to receive commission, my lord, for services, my lord, which one does not know as to, my lord, what services it is expected to render. And, my lord, this ultimately resounds in, my lord, two things. One is an increase of, my lord, the rate either at the hands of, my lord, the distiller bottler, or, my lord, it, my lord, leads to, my lord, a rate cut so far as, my lord, its profits are concerned, or it or it, my lord, ultimately manifests in increase of the prices. Well, as I was telling your lordships yesterday, my lord, today, my lord, there is something called the ex-bond price that is fixed by the government, by the excise department. The ex-bond price includes the, my lord, price at which the distiller or bottler supplies to the bonded warehouse, the bonded warehouse commission. So, my lord, up to that we have the ex-bond price which is fixed. Now, let us say the ex-bond price is fixed at 1,000 rupees by the government. But that originally would have ultimately captured within itself, my lord, first the price that is to be paid to the distillers, bottlers and the bonded warehouse. Now we have within that price a third entity. So that price will now have to, my lord, ultimately facilitate, my lord, payments to not only the bottlers, distillers, but to the central bonded warehouse and the bonded warehouses. With, my lord, one wonders what additional service, because ultimately, my lord, the bonded warehouses are not done away with. Now, if today it is not a part of the ex-bond price, then, my lord, it will ultimately reflect in addition of, my lord, the central bonded warehouse commission in the hands of the retailers, which will ultimately find its way to the consumers. So, my lord, that is, my lord, the structure we have at present. Now, my lord, the second question. So, first was, my lord, the question of, my lord, what is the need for, my lord, CBW? Second is, my lord, how it affects the price structure of the goods without, my lord, any additional services really being provided. And the third is, my lord, how it manifests in, my lord, skewering the level playing field that was prevalent for so long. Now, my lord, so far as the bonded warehouses are concerned, they were all, my lord, ultimately proceeding to, my lord, place orders on the basis of, my lord, the market demand. So, my lord, the market forces were ultimately, my lord, driving the demand for, my lord, the different brands of liquor. For example, my lord, if today there is a, my lord, demand for a particular brand of beer in a particular region, my lord, that reflects in, my lord, the demand on the bonded warehouse in that region, which translate into the placement of an order for, my lord, that variety or that, my lord, brand in the on the manufacturer or bottler. And, my lord, that is how the market was, my lord, conducting itself. Now, my lord, now what will happen, and, my lord, that is, my lord, an apprehension that we are very clearly expressed. Now, my lord, with the CBW being the sole importing authority, the CBW decides, my lord, how much of which brand to, my lord, import from which manufacturer. Now, my learned friends will argue that no, the scheme provides that the CBW or the central bonded warehouse will maintain a minimum stock of all brands of liquor for a period of, my lord, 3 months. First, my lord, there is nothing to suggest as to how, my lord, this minimum quantity of all brands will be determined for, my lord, a month or for a period of 3 months or for any given point of time. Secondly, so far as this is concerned, the second, my lord, aspect is that, my lord, today we find that so far as this is concerned, my lord, there is nothing provided in the amendment of, my lord, the amendment notification, which says as to, my lord, how, my lord, this demand is to ultimately be structured, my lord, from the consumers through the retailers through the bonded warehouses. Now, my lord, the bonded warehouses are supposed to place their orders on the central bonded warehouse. The central bonded warehouse is supposed to, my lord, make supplies to the bonded warehouses within a period of 60 days. But, my lord, they are supposed at the same time to maintain a minimum stock of all brands at all points of time, so that, my lord, upon a bonded warehouse approaching a central bonded warehouse for a particular variety or a particular brand of liquor, it can immediately get that supply. Now, the difficulty is, and it's a practical difficulty, that, my lord, today, if they do not stock a particular brand of liquor, and, my lord, the bonded warehouse approaches them for that particular brand, in that case, my lord, ultimately if they say that, sorry, we don't have this brand, the bonded warehouse will opt for another brand because, my lord, its stores cannot run dry. Its warehouse cannot run dry, its retailers cannot, my lord, run dry, and, my lord, the customers will then go for other varieties. The third factor is that, my lord, here, my lord, we have, my lord, a representation from the government, my lord, which I pointed out yesterday to your lordship, which says that we will not disturb the market forces. We will let the market forces determine as to what is the commission that the bonded warehouses, that the central bonded warehouse will charge. Now, my lord, that is a very frightening situation, because if your lordship, my lord, kindly once comes to page 71 of the writ petition, well, this is something that, my lord, it showed. I just need to emphasize this once again before I move forward. Well, this is the response of, my lord, the government to my representation of what I thought, my lord, aids these notifications or these amendments, and well, how they will impact me. Well, the government's response to my lord, apprehensions starts at page 70. Well, I am only drawing your lordship's attention for the present to paragraph 9 at page 71. At the bottom of the page, paragraph 9, this is what the government represents.
Yes.
That the creation of CBW, that is the central bonded warehouse, does not entail any additional cost of operations to the existing tiers. Well, this is completely wrong. It does, because they, my lord, contemplate the payment of a commission to the CBW. And that becomes clear from, my lord, the next part of the same sentence. That the creation of CBW does not entail any additional cost of operations to the existing tiers, that is, liquor companies, bonded warehouses, retailers. Then, my lord, this is very important. The margins payable to CBW should be regulated purely on free market play. The government does not intend to regulate the margins for CBW, as it would tantamount to interference with the market and price dynamics across various brands and types of liquor. Now, my lord, what this essentially means is, my lord, the CBW will be entitled to determine as to what commission it would charge brand-wise. Now, my lord, kindly see as to, my lord, what this would wreak in the market. Because, my lord, then, my lord, it can say that for a particular brand, I shall charge a commission of 17%, for another I shall charge a commission of 2%. Which means that, my lord, one brand becomes more expensive, the other brand becomes cheaper, and, my lord, this naturally affects, my lord, the market for that brand. Coming. And, my lord, this is the representation. The margins payable to the CBW should be regulated purely on free market play. The government does not intend to regulate the margins for CBW, as it would tantamount to interference with the market and price dynamics across various brands and types of liquor. Now, my lord, these are the apprehensions expressed, and, my lord, if you now look at
yesterday, Mr. Shah, it's all marked. Paragraph 9.
Yes, my lord.
Yes, we have noted all that.
Very well, my lord. I shall just move ahead, my lord.
Yes.
Now, my lord, so far as this is concerned, my lord, now, my lord, this creates a monopoly in the hands of, my lord, a private party.
Yes.
And, my lord, so far as this is concerned, because, my lord, your lordship has seen, although, my lord, CBW is chosen through an auction process, the auction process limits the creation of the CBW to 1.
But where is the price marked? At the bottler's end or by CBWD?
Well,
say
so
on a
far as-
bottle, that price tag, where is it affixed?
Well, so far as this is
We
concerned,
have understood that the bonded warehouse feels the market, makes a requisition to the central bonded warehouse under this notification. Central bonded warehouse will place an order with the bottlers for
Right.
supply, taking into account commission, etc., its margin, etc. Now, where is the price kind of?
my lord, the price is supposed to be, my lord, because, my lord, I had also shown your lordship, my lord, a letter that had been written
Perhaps the bottlers will do it. The bottlers will.
The bottlers. Now, my lord, what the central bonded warehouse, upon being formed, had written is saying that please create your rate chart upon making a provision in your rate chart for payment of 25% commission. Now, my lord, 25% commission would mean that this would ultimately be a part of the ex-bond rate. Now, ex-bond rate being fixed by the government, my lord, this my lord, rate increase will have to be observed by the bottlers. But, my lord, at the same time, the government says, my lord, this is why I, my lord, took the trouble of again pointing out this paragraph to your lordship, that it is the free market force which will determine the commission that the central bonded warehouse will, my lord, charge. Which means, my lord, ultimately, it is the demand for the goods, my lord, that will determine the commission.
Would the government rate be increased after this notification, or would it remain the same?
It can't remain the same, my lord.
So the central bonded warehouse would eat up 8% of it.
Eat up 17%. 17% to the central bonded warehouse, 8% to the bonded warehouse. So 25% impact. Where previously the impact was 8%, it now becomes 25%. And my lord, the reason I repeat this is, my lord, because, my lord, let us now, my lord, proceed on the premise that it is, my lord, going to be a part of the ex-bond rate. My lord, ex-bond rate fixed by the government at 1,000 rupees. Out of this 1,000 rupees, or my lord, let's say it's 100 rupees. Out of this 100 rupees, 8 rupees was previously to be the commission of the bonded warehouse.
No,
now, my lord, it will be 25 rupees.
17 has to be added.
17 plus 8.
Included.
And, my lord, this has to now come out, my lord, if it is the ex-bond price, come out of the pockets of the manufacturers or distillers. And, my lord, the second part is, my lord, today, how does one then, my lord, keep the check and balance on this monopolistic entity that is now created? Because this is the sole entity in the hands of, my lord, a private party, which ultimately controls the entire.
Earlier upon sale, after payment of 8% commission, the rest of the money would have gone to the bottlers.
That's right.
Now, 17% would be taken away from that and go to the central bonded warehouse.
An additional 17%. And it is additional 17%. And, my lord, here, my lord, curiously, my lord, while, my lord, the central bonded warehouse, my lord, writes to one of the parties saying that make a provision for 17%, which later I have shown your lordships. My lord, here, my lord, the government's, my lord, clarification says that ultimately they will be free to determine what the rate they will charge from, my lord, different bottlers or different, my lord, manufacturers or different distillers, which is, my lord, going to affect the market, which is, my lord, going to ultimately affect the free market, my lord, forces at play. Now, my lord, this is,
which means that they can alter the government rate.
No, my lord, what they can do is, my lord, they can say, for example, my lord, they can create an artificial demand for one brand as opposed to the other by saying that we have stocks of this brand, so you take this brand. And, my lord, they can also in addition say that I am charging a higher commission for this brand and a lower commission for another brand, which will, my lord, drive up the demand for the other brand and, my lord, depress the demand for, my lord, a particular brand which is, my lord, foisted with a higher rate of commission. And, my lord, there is no check and balance provided here. So, my lord, this whole thing, my lord, affects the level playing field which was in existence, my lord, amongst the 45 bonded warehouses, which would then, my lord, control the, my lord, the importation of liquor into the state of Meghalaya, acting on the basis of the real demand, my lord, on the ground. So, my lord, real demand on the ground would no longer be a reflection. It would ultimately, my lord, be, my lord, capable of, my lord, being manipulated on the basis of stocks that, my lord, the central bonded warehouse decides to, my lord, import and keep and to make available.
Yes.
And, my lord, also, my lord, it would be, my lord, affected on the basis of the margin that it decides to charge on different, my lord, bottlers and manufacturers. Now, my lord, so far as this is concerned, my lord, this, my lord, is something that ultimately, my lord, they could not have done for several reasons. Now, my lord, I had, my lord, at this point of time, my lord, the court had called upon me to, my lord, say that what is the prejudice? What is the prejudice that we will suffer in case, my lord, this notification survives? My lord, to that, my lord, we were called upon to file an affidavit, and we had filed an affidavit which was affirmed on 14 September 2021. My lord, may I, my lord, just take your lordship quickly through that affidavit? Affidavit of 14 September 2021. It's really a supplementary affidavit to the writ petition filed pursuant to a direction of court.
I can't hear you. That's written. I want to read.
Well, may I request your Lordship to please have a look at page 4, paragraph 4 of this affidavit. Well, if your Lordships have, my Lord, page 4, paragraph 4, my Lord, there are a few bullet points which highlights, my Lord, the manner in which, my Lord, the supply chain would be affected and the route to market, my Lord, would be affected.
Page 13 of the affidavit.
Page 4, man. Page 4 of the affidavit, paragraph 4 at page 4.
Yes.
Let me just read this one paragraph. It is most respectfully submitted that given that there are no checks and balances in place, the existing mechanism permits the CBW licensee to act arbitrarily and to the detriment of other players in the trade in liquor. In this regard, the CBW licensee can, at the very least, do all or any of the following. While the impugned amendment rules provide for maintenance of minimum stock of 3 months at any point in time by the CBW licensee, there is no mechanism to determine 1. What would comprise the minimum of 3 months, 2. Who would decide such minimum stock, 3. In the event of disagreement on the quantum of stock, how would a decision on quantum be arrived at? As such, there is no mechanism for the suppliers to determine the demand and availability of stocks. Well, this is the first point. Then, in the absence of any of the aforesaid stipulations, the CBW licensee would have untrammeled powers to dictate the availability of products irrespective of the demand of the consumers. Then it could now arm twist the manufacturers or suppliers to agree to their exorbitant demand of margin or trade items, or to sell their products to it at discounted rates, given that it is the only source to access the market in the state of Meghalaya. Well, I can say that unless you pay me a higher rate of commission, I will not stock your goods. Moreover, the CBW licensee is at liberty to pick and choose with whom it would transact, and that too on credit or cash basis. Now, my lord, you can say that, my lord, for a favored my lord, supplier, I'll give you a larger period of credit and a shorter period of credit to, my lord, a person whose, my lord, stocks are not, my lord, required to be, or my lord, favored stocks to be kept in the stores of the CBW. Even in terms of cash and credit, the CBW licensee can arbitrarily impose any credit period on the supplier. For instance, it can purchase goods from a supplier on the basis of a week's credit period. On the other hand, it can impose a credit period of 60 days on a competing supplier. Additionally, given its monopolistic position, the CBW licensee may determine supply payment terms to be paid by the manufacturers or suppliers, such as the petitioner's member companies, such as funding of excise duty, taxes, transit insurance, freight charges, liability towards breakage, warehousing charges, etc. And given that this is very important, this is ultimately a very, very important factor here. Given that the constituents of the CBW licensee have their own manufacturing plants in the state, the CBW licensee can promote the brands of liquor manufactured by its constituents to the detriment of other competing products. In case of disputes with a particular supplier or a supplier not conceding to the exorbitant demands of the CBW, the market would go dry for the supplier's brands. And then paragraph 5, the impugned amendment rules do not require the CBW licensee to disclose the quantity of stocks imported by it or the quantity of stocks which are currently available with it. This results in lack of transparency in trade of liquor in the state of Meghalaya, which could be used to the advantage of the CBW licensee and the disadvantage of the suppliers who do not toe the line of the CBW licensee. And then paragraph 6 also, my lord, very important. It is verily believed that the constituents of the CBW licensee also own and operate certain bonded warehouses in the state of Meghalaya. As such, the CBW licensee can also at its discretion, favor its own bonded warehouses over other competing bonded warehouses, which would create imbalances in the geographical distribution of the products and unfairly create pockets of influence within the trade channel. Well, these are the concerns that we highlighted before this honorable court as to how it affects the trade and consequently affects the petitioners. Now, so far as this is concerned, now just to cut the matter a little short, there are three principal grounds on which the challenge against these notifications was brought. Ground number one is that it creates a monopoly, which is against the mandate of the Constitution in Articles 19(1)(g) and Article 19(6). It creates a monopoly, and that cannot be permitted. Now, so far as this is concerned, Article 19(1)(g), as your Lordship knows, guarantees the right to carry on trade and business to all concerned. The state can, however, prohibit the trade in certain items, declaring to be pernicious, like gambling, prohibited. Now, liquor, tobacco, these are not prohibited. These are not inherently pernicious. They are regulated items. But the courts have from time to time used the expression res extra commercium insofar as these goods are concerned also, which really applies to prohibited items or pernicious items, which should not be allowed in trade at all. But I should show your Lordship that our Supreme Court and our Constitution has ultimately accepted the position that yes, it's going to be regulated. And if there is regulation to be imposed, either the state can regulate it entirely, so the state monopoly is something that is permitted. But if it is not a state monopoly, a state cannot ultimately control it, as a monopoly through a private entity or private player. I can't hear you. To get up and tell me. The second part is, even assuming for the sake of argument that this was permitted, the question would be, what is the discernible purpose of this amendment or notification?
Right to do business, state has the power to impose reasonable restrictions. So whether this is a reasonable restriction or not, that's all.
Yes, state has the power to impose reasonable restrictions, but not a power to create monopoly. That is the accepted position. Here, it is creating a monopoly. And the reasonable restriction would be where the state says that I restrict the trade by saying that I shall control the entire trade myself. That is permitted.
Monopoly in certain businesses.
That's it.
But as far as essential commodities are concerned, essential utilities are concerned, like electricity.
Yes.
CSC has monopoly over
yes.
supply in Calcutta.
Yes.
And DVC has over the other western areas of West Bengal.
That's right. That's right. Now, so far as this is concerned, now the second part of it is, so therefore the second part is Article 14. Violation of Article 14, because if today there's an amendment which creates such monopoly, and does so without really a discernible purpose or a real nexus with the trade, and ultimately does so without introducing the relevant or required or necessary checks and balances, which ultimately is likely to affect or skew the level playing field, then it is arbitrary and it will have to be interfered with. The third part is, it cannot be a notification which is made under the statutory provisions. Cannot be ultimately ultra vires statute itself. So statutory ultra vires is one of the grounds of challenge. So these three principal or essential challenges that we have brought forward so far as this is concerned.
Yes.
Now, so far as this is concerned, now the question is at the first question here, your Lordship will wonder that why was this necessary? Now, this brings us to a little factual inquiry, which now stands proved and accepted. Now, if your Lordship will now kindly take up an affidavit that was filed by the respondent number 3 again, pursuant to order of court. Thank you. Yes, sir. Well, this is an affidavit filed by the respondent number 3. Well, this was affirmed. Well, in May 2023. May 2023.
September 23, I think, May 23.
It's an affidavit of one Neeraj Kapoor.
Can you get May 23?
Well, that's the respondent number 3.
This is,
It's a very short affidavit with annexures. And again, filed pursuant to direction of court.
This, I don't know why this direction was made, because a statute or notification or subordinate notification, you have to read the notification itself.
Yes.
You cannot explain it.
yeah, correct.
I accept that position, except that what
We will not
transpires.
look into this.
Very well. But what essentially transpires is that here,
If there was any discussion in the legislature or any committee papers, that we can go into.
Absolutely.
very well. May I, just without troubling your lordship with this affidavit, request your lordship to kindly have a look at one order. This records, this views with suspicion, the very purpose for which, these notifications were introduced. This is an order of 20th June 2023.
Next to something, well, how does that?
Sorry, Mr. Shah.
This is an order dated 20th June 2023.
Okay.
You get it? Which annexure to something? Or?
No, it is in the course of hearing.
Not in the, any. Okay, you'll have to find it. Just tell me what you were saying in the morning. Can you find it? Order is 20th June, right?
20th June 2023.
Yes.
The first few paragraphs. The respondent number 3 has disclosed its partnership deed, which reveals that there are 4 partners. According to the petitioners, the curious case of the third respondent, Central Bonded Warehouse, is that its partnership deed was executed sometime in September 2020, as if in anticipation of the new policy that was brought into place by the government in October 2020. So, the notifications are of October 2020, and the CBW, or the entity which was awarded the CBW, came into existence in September 2020. The petitioners also point out that all the 4 partners of the third respondent, Central Bonded Warehouse, also own distilleries, whether individually or with others, and further own or control several bonded warehouses. This by itself is against a fair process, since as owners of distilleries, the partners are in the same position as the petitioners herein, and also owners of bonded warehouses, the partners become clients also of the Central Bonded Warehouse. In the supplementary affidavit filed the petitioners, it is indicated that though the government has filed and fixed an ex-bond rate and the extent of commission to be passed on to the bonded warehouses, variable rates had been sought to be charged or threatened to be charged by the Central Bonded Warehouse from different manufacturers. According to the petitioners, this would be completely against there being a level playing field, since the higher rates charged from certain manufacturers and the lower rates charged from certain other manufacturers will have an impact on the quantum of supply, the products that ultimately reach the retailer's shelves. In addition, the petitioners claim that there are certain incentives which are selectively offered by the CBW or proposed to be offered that may further distort the price mechanism. At the same time, the petitioners point out that it is the considered stand of the state that it will not interfere in pricing, as that should be determined by the market forces. The essence of the petitioner's contention is that if different sets of rules are applied to different suppliers of liquor to the CBW is in a monopolistic position to control the quantum of supplies obtained, and even though the CBW may ensure that it takes supplies from every manufacturer, yet the quantum of the supplies would be dependent on the extent of income or profit that the CBW is able to glean from the relevant transactions. In the previous regime, when there were several bonded warehouses, the manufacturers or distillers would enter into individual agreements with the bonded warehouses, and though the terms thereof could be different, there would have been a level playing field and agreements entered into at arm's length. The petitioners submit that just as if all the bonded warehouses formed a cartel and dictated terms to the manufacturers, some manufacturers may have benefited while others may have suffered, the CBW in effect is doing or intending to do the same. Prima facie, an element of prejudice is made out, justifying the institution of the present proceedings. At the end of the day, it is for the state to ensure that the rules are in place that do not allow a solitary entity that has replaced a group of entities to indulge in monopolistic practices or dictate terms to the manufacturers or distillers, or be in a position to decide which product and of what amount would land on the retailer's shelves. The state should know better and should bring in rules that will allow the demand at the level of individual buyers to direct the supply of the product, rather than a state-appointed entity taking into account its profit-making exercise for deciding the same. And my lord, here, my lord, CBW had sought, my lord, time to ascertain whether it was charging differently, and my lord, ultimately, my lord, affidavits have been filed by the state saying that yes, it accepts that, my lord, the existence of a single CBW, my lord, is going to, my lord, be monopolistic in its approach. Now, my lord, so far as this is concerned, my lord, we now have, my lord, a CBW which is constituted of, my lord, both upstream and downstream players. Now, my lord, so far as the challenge is concerned, let me now straight away take your lordship to the challenges. I have shown your lordship, my lord, how it affects the market or the route to market. I have showed your lordship the legitimate apprehensions. I have showed your market that there is, lordship, that there is no check or balance, my lord, that will ultimately allow, my lord, a level playing field to survive amongst the different, my lord, manufacturers, bottlers, distillers, and, my lord, the different bonded warehouses. Now, my lord, to take your lordship directly to the challenge. My lord, may I, my lord, first dwell on, my lord, the first challenge, that, my lord, this is something that is, my lord, statutorily ultra vires. For that, my lord, may I request your lordship to please have a look at the, my lord, the Excise Act, the Meghalaya Excise Act.
The Assam Excise Act, huh?
It is the same exercise, my lord, which has been adopted by the state of Meghalaya. My lord, may I just show you, lordship, my lord, a few definitions first. My lord, first, my lord, section 3, if your lordship sees. My lord, this is the definition section. At, my lord, 12A, so 3 subsection 12 small a. My lord, this is the definition of, my lord, intoxicant. Intoxicant means only liquor or intoxicating drug. So, my lord, liquor in all its, my lord, manifestations and intoxicating drugs are, my lord, covered. Then, my lord, the definition of liquor, which is subsection 14. Liquor means intoxicating liquor and includes all liquid consisting of or containing alcohol. I shall not read further, my lord, this is enough. So, my lord, both country liquor and, my lord, IMFL would, my lord, constitute liquor. Thereafter, kindly have a look at.
Also, Tali and Pachwala.
Yes.
That is country, comes under country.
Now, my lord, if your lordship will now please have a look at, my lord, section 4. Well, at section 4, well, it is the power, my lord, under the statute to define country liquor and foreign liquor. Now, well, here your lordship will find that, my lord, reference in the notification is made to IMFL, which is, my lord, Indian-made foreign liquor, Indian-made foreign liquor. So, which, my lord, does not include country liquor. Well, section 4 reads, the state government may, by notification, declare what for the purposes of this act shall be deemed to be country liquor and foreign liquor respectively. Now, my lord, lordship will see that, my lord, the notifications talk only of foreign liquor, not of country liquor. Well, thereafter, my lord, I shall, my lord, skip over the portions that, my lord, are not immediately relevant. Please have a look at section 16. Well, this provides for the establishment or licensing of, my lord, warehouses amongst, my lord, other things. Section 16 talks about establishment or licensing of distilleries, breweries, and warehouses. The Excise Commissioner, with the sanction of the board, may, then if your lordship will skip over to D, establish or license a warehouse where any intoxicant may be deposited and kept without payment of duty, and also discontinue any warehouse so established. Well, this is a provision under which bonded warehouses are established, because they are allowed to be stored there without duty. Duty is to be paid, my lord, once the goods leave the bonded warehouse. Now, my lord, please have a look at, my lord, section 19, which is the all-important section. May I read this section a little slowly? The state government may grant to any person on such condition and for such period as it may think fit the exclusive privilege of manufacturing or of supplying to licensed vendors or of manufacturing and supplying to licensed vendors any country liquor or intoxicating drug. So, my lord, this, my lord, allows the grant of exclusive privilege in the matter of supply, my lord, of country liquor or intoxicating drug to, my lord, a particular person, and, my lord, within a specified local area. So, my lord, there are two, my lord, parts of this. One is, my lord, this exclusive privilege is reserved under the statute only in respect of, my lord, country liquor. And, my lord, it is also to be confined to a specified local area. Now, my lord, here your lordship find that this exclusive privilege is now granted, my lord, throughout the state, so not a designated, my lord, specified local area, and it is granted in respect of IMFL. Now, my lord, if the statute had intended that IMFL should also be covered by this provision, my lord, foreign liquor should also, my lord, be the subject of grant of exclusive privilege, then, my lord, certainly a provision to this effect would have been made. Now, my lord, here today your lordship finds that this is, my lord, the statutory confine, and ultimately we have a subordinate legislation through a notification, which, my lord, seeks to upstage, my lord, the, my lord, substantive provision or the plenary legislation. So, my lord, while the plenary legislation, my lord, restricts the grant of such exclusive privilege under the mandate of the statute only in case of, my lord, country liquor or intoxicating drugs, which does not include within its scope or ambit foreign liquor or Indian-made foreign liquor, ultimately the license proceeds to, my lord, grant, my lord, this right, my lord, to the central bonded warehouse, the right of exclusive privilege. Now, my lord, so far as this is concerned, now your lordship will kindly have a look at the rule-making power conferred by, my lord, the statute. That is at section 36. Well, today section 36 has to be read, keeping in mind the fact that, my lord, ultimately the subordinate legislation must yield to the plenary legislation and cannot, my lord, overtake it. Now, please have a look at, my lord, section 16, section 36. The state government, the state government may make rules for the purpose of carrying out the provisions of this act. My lord, please, my lord, mark these words. The state government may make rules for the purpose of carrying out the provisions of this act. So, my lord, it cannot, my lord, make rules which will either, ultimately offend any of the provisions of the act. State government may make rules for the purpose of carrying out the provisions of this act or any other law for the time being in force relating to the excise revenue. Then, my lord, kindly have a look at subsection 2. In particular and without prejudice to the generality of the foregoing provisions, the state government may make rules. Then kindly see 2D. Regulating the import, export, transport or possession of any intoxicant. Then 2E. Regulating the manufacture, supply, storage or sale of any intoxicant. And in particular regulating, well, then there's 1, 2, 3, 4. Well, under Roman 4, your lordship will find the bottling of liquor for sale, with which we are not really concerned. And then F. Regulating the deposit of intoxicant in warehouses and the removal of such articles from warehouse, distilleries or breweries. And also regulating the periods for which and the persons to whom licenses for the sale of any intoxicant may be granted, and providing for the selection of sites at which shops may be opened. Well, this is the rule-making power. Now, my lord, if your lordship, my lord, while reading this also, but have a look at subsection 4 of section 36.
Mr. Shah, you're relying on subsection 4.
It's introduced System Act of 74.
Period of the act to discourage procreation of monopoly.
Yeah, but it's there, introduced since 1974.
It's there.
It's there in the Meghalaya Act also. Not taken away.
Yes, it's there.
Will it also see subsection 4? While framing rules under this act, the state government may provide from time to time for reservations to be made in favor of persons belonging to the scheduled castes, scheduled tribes, and other backward classes, and educated, unemployed youths with particular reference to the economic backwardness for the purpose of this, and may also provide for discouraging or preventing monopoly in matters relating to such license, passes, and permits. So, my lord, monopoly is expressly discouraged. But, my lord, what is perhaps more important, my lord, when we are looking at a statute, and we have seen, my lord, what section 19 provides. My lord, section 36 opens with the language, with the words, that the state government may make rules for the purpose of carrying out the provisions of this act. Now, my lord, carrying out the provisions of this act would mean that you grant, my lord, exclusive privilege, my lord, only in the matter of, my lord, trade in, my lord, country liquor or intoxicating drugs. And, my lord, that would not allow you to make or frame rules which would be ultimately, my lord, going beyond the substantive provision of the law, and, my lord, would allow exclusive privilege to be granted also in the matter of, my lord, carrying on of trade, my lord, in respect of Indian-made foreign liquor, IMFL. My lord, this is, my lord, now a very well-settled proposition of law, that, my lord, today you can't really travel. Well, in the course of, my lord, a subordinate legislation or legislating a subordinate, my lord, provision, you cannot travel beyond the scope of the main statute itself. You cannot offend the plenary legislation. Well, that is, my lord, well established now. Now, well, so far as this is concerned, well, there are scores of, my lord, decisions on the issue, but, my lord, may I, well, let's start with pointing out to your lordship, my lord, a more recent decision, well, of Delhi High Court, but, my lord, authored by Justice Sanjeev Khanna, well, lord, which ultimately, my lord, looks at the law in its entirety and, my lord, takes into account all, my lord, previous judgments or all, my lord, relevant previous judgments on the subject. Well, lord, may I
Where is such a copy?
Copy দিচ্ছেন আর reference দিচ্ছেন, yes.
Copy the.
Kindly give me just a moment.
ठीक है, send it over. Give a copy to Mr. Banerjee.
I have one copy. You have another copy? No, the High Court Judge, Justice Sanjeev Khanna's judgment. Well, I am extremely sorry, my lord. Seem to have got the copy of the wrong judgment. Well, I shall show your lordship, my lord, the other judgments, my lord, on the subject. My lord, before I travel, my lord, elsewhere. My lord, if your lordship will kindly have a look at, my lord, some of the judgments, my lord, other judgments which, my lord, have governed this field. My lord,
No, Mr. Shah, if you come to this section 19,
yes, my lord, section 19.
exclusive privilege of manufacturing or of supplying to licensed vendors any country liquor and Rule 36 E regulating the manufacture, supply, storage or sale of any intoxicant. So
If you look to
this
see-
would be confined to country liquor.
Yes. My lord, because, my lord, that is, my lord, substantive provision. If the act, my lord, intended that it's exclusive privilege, my lord, should be extended to IMFL also, it would have provided for that. And my lord, that is the, my lord, doctrine of unius ext. The expressio unius est exclusio ulterius, my lord, which is one of, my lord, the subsidiary rules. It says where the statutory language is plain and the meaning clear, there is no scope for applying the rule. So, my lord, if today something is excluded by necessary implication, because the statute does not provide for it, one cannot ultimately include that or incorporate that into the statute. Now, my lord, kindly see the, my lord, heading of the section itself. Now, my lord, here, so far as this is concerned, but your lordship will, my lord, also see, my lord, so far as the scheme of the act is concerned, my lord, chapter 3, which is sections 10 to 14, my lord, that talks about import, export and transport.
No, but coming back to section 19,
Yes.
does it not imply an agency of country liquors?
Let me read this again.
Exclusive privilege of manufacturing
Yes.
or of supplying. It doesn't use the word sale.
No, supplying. We are talking about supply.
to licensed vendors that manufacture.
Or supply.
Vendors are licensed to act as agents, franchisees, supply. Thereafter, they will sell.
Well, may I just read it like this? Well, here, exclusive privilege of manufacturing, we understand that, or, well, this is, my lord, not manufacture and supply, it is an
Or of
independent.
supply.
Or supplying. Now, well, supplying includes, my lord, the route to market. The supply, my lord, includes, my lord, the bonded warehouse, the central bonded warehouse, it is the route to market. My lord, supply to licensed vendors. Supply to whom? To licensed vendors. So, my lord, if today the licensed vendor is, my lord, the bonded warehouse, then supply to bonded warehouse. If today the licensed vendor is the retailer, then supply to the retailer. So both these, my lord, aspects would be covered. The question is, my lord, why then, my lord, would, my lord, a special privilege be carved out only for, my lord, country liquor?
Because it's dangerous. Sometimes it's very poisonous and kills people. So,
Well, that-
so they will identify the manufacturers and also the agents who will store, who can only have custody of
So
them.
therefore, my
And
lord,
not throw them.
I am very grateful.
Across
So,
the
my lord,
market.
for whatever reason, the legislature in its wisdom thought it fit to, my lord, ultimately restrict this exclusive privilege, my lord, of manufacture or supply of country liquor or of intoxicating drugs to, my lord, individuals chosen by the state.
Yes.
But, my lord, that, my lord, benefit or privilege is not extended in case of IMFL liquor because it is not, my lord, so, my lord, dangerous. Because, my lord, ultimately IMFL is, my lord, all manufactured by, my lord, well-known manufacturers who are, my lord, ultimately subject to, my lord, their necessary controls and checks. So, my lord, the question is, my lord, whether one can, my lord, ultimately read, my lord, section 19, but in a fashion which will expand it beyond, my lord, the scope of the words employed in the section, and, my lord, ultimately include within, my lord, or, my lord, include really, so to speak, my lord, country liquor and IMFL, when, my lord, IMFL is expressly excluded. And it is, my lord, in that, my lord, light that one will have to ultimately look at the rule-making power, because ultimately the rule-making power is a power to, my lord, give effect to the provisions of the Act. I would have completely appreciated that, my lord, a rule-making power is, my lord, ultimately employed to devise a set of rules, my lord, for the purpose of ultimately creating or granting an exclusive privilege to, my lord, an entity or, my lord, to a individual, so far as the sale of country liquor is concerned. It can be manufacture of country liquor and sale of country liquor, or manufacture and sale of country liquor. But, my lord, not, my lord, ultimately something that extends, my lord, to, my lord, my lord, something that goes beyond. So, my lord, the first point I make is, my lord, it is ultra vires the statute. And, my lord, Rule 36 does not, my lord, afford the protection of, my lord, framing a rule which, my lord, ultimately overwhelms the substantive provision of the Act itself.
Yes.
My lord, so far as this is concerned, my lord, I shall give your lordship the, my lord, relevant judgments.
Yes.
My lord, I do not want to waste your lordship's time, my lord, on this. My lord, the second part is, if your lordship would please have a look at, my lord, the Constitution once. My lord, when we talk about reasonable restriction, my lord, please have a look at, my lord, 19(6) once. The 19(6), which ultimately qualifies 19(1)(g). Well, ultimately, my lord, this reads, nothing in subclause G of the said clause shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing in the interest of the general public reasonable restrictions on the exercise of the right conferred by the said subclause, and in particular nothing in the said subclause shall affect the operation of any existing law insofar as it relates to or prevents the state from making any law relating to, then kindly come to Roman 2, the carrying on by the state. Now, this is where state monopoly is permitted. The carrying on by the state or by a corporation owned or controlled by the state of any trade, business, industry or service, whether to the exclusion, complete or partial, of citizens or otherwise. So, my lord, state monopoly is permitted, and my lord, it is permitted through the state itself or through a corporation owned or controlled by the state, and not otherwise. And my lord, when we talk about reasonable restriction, my lord, kindly have a look at this. My lord, when can a reasonable restriction be ultimately imposed? It says, my lord, insofar as my lord, it says, the clause shall affect the operation of existing law insofar as imposes or prevents the state from making any law imposing in the interest of the general public reasonable restrictions. Now, my lord, therefore, one will have to answer the test of, my lord, how, my lord, this subserves the interest of the general public. So, my lord, a reasonable restriction would be permitted only when it subserves the interest of the general public. Of course, my lord, I don't say my lord, for any point of time that, my lord, ultimately state monopoly is not permitted. That is permitted under subclause 2 of Article 19(6). However, it says state shall exercise monopoly control through the state itself or through any, my lord, corporation or entity, my lord, owned and controlled by the state. Now, in this case, my lord, one will, my lord, look in vain to find as to, my lord, how, my lord, this piece of, my lord, subordinate legislation is, my lord, in the interest of the general public, or how it, my lord, chooses to impose reasonable restrictions. In fact, my lord, it, my lord, restricts the right to carry on trade and business without any purpose, without any discernible purpose, which has been, my lord, the cornerstone of, my lord, all judgments, my lord, under Article 14. And, my lord, the third point, of course, my lord, Article 14 itself, my lord, it says, my lord, it affords to, my lord, persons equality before law and equal protection of law. And, my lord, this has been, my lord, interpreted times without number to, my lord, prevent any arbitrariness, any, my lord, lack of transparency, any unfairness, any undue restriction, any untrammeled power, any unbridled discretion in matters. And all of this has now been accepted as, my lord, ills that, my lord, ultimately accompany, my lord, these notifications of October 2010, my lord, because, my lord, they ultimately confer unbridled power, no checks and balances, etc. Now, my lord, may I start, my lord, showing your lordship, my lord, the judgments on, my lord, each of these subjects. My lord, may I first, my lord, show to your lordship, my lord, on the matter of, my lord, Section 19 and how, my lord, that will affect matters. My lord, please have a look at, my lord, first, my lord, my lord, a decision of the Supreme Court reported in 2000, Volume 3 Supreme Court cases, page 40.
Thank you.
My lord, may I request your lordships to straight away have a look at, my lord, paragraph 7 onwards. Well, this was a matter, well, dealing with, well, the HP, Himachal Pradesh Ceiling on Landholdings Act. But, well, kindly have a look at this page, paragraph 7. Section 4 of the Act defines the permissible area which a landowner, a tenant or a mortgagee with possession or a person holding partly one or other of the above status may hold. Section 6 places a ceiling on the entitlement to hold any land beyond what is permitted by the Act. Section 7 empowers the state government to determine the surplus area of the land held by anyone ignoring the transfer after the appointed date of a land held in excess of permissible area, except bona fide transfers. Section 5 of the Act provides for exemption and enacts that the provisions of this Act shall not apply, amongst others, to tea estates. Then, my lord, kindly skip over and come to paragraph 8. Counsel for the appellant submitted that the lands covered by 7 categories as defined in clauses A to G of Section 5 have been excluded from the applicability of the provisions of the Act. Section 26, well, that's a rule-making power, delegates to the state government the legislative power of making rules, which delegation is circumscribed by the expression for carrying out the purposes of this Act. Similarly, as in our case, in exercise of such delegated power to legislate, the state government cannot bring within the net of the rules what has been excluded by the Act itself. We find merit in the submission so made. Tea estates are excluded from the provisions of the Act by Section 5. Tea estates is defined, etc. Then, my lord, may I request your lordship to kindly look at, my lord, the latter part of the same paragraph, starting with the words clearly. Clearly, the impugned proviso, my lord, this is about This is towards placitum B at page 257. About 6 lines from the top of the page, clearly. It reads clearly the impugned proviso is beyond the rulemaking power of the state government as conferred by the Act. It is well settled that the legislature cannot delegate its essential legislative functions, which consist in the determination or choosing of the legislative policy and of formally enacting that policy into a binding rule of conduct. What is permitted is the delegation of an ancillary or subordinate legislative function, or what is fictionally called the power to fill up the details. Well, a reference is made to G.P. Singh's interpretation of statutes. Then it refers to my Lord Supreme Court Employees Welfare Association versus Union of India, where it was held. A delegated legislation or a subordinate legislation must conform exactly to the power granted. Rules, whether made under the Constitution or a statute, must be intra vires the parent law under which power has been delegated. In General Officer versus Commanding-in-Chief versus Dr. Subhash Chandra Yadav, it has been held, before a rule can have the effect of a statutory provision, two conditions must be fulfilled, namely, one, it must conform to the provisions of the statute under which it is framed, and two, it must also come within the scope and purview of the rulemaking power of the authority framing the rule. If either of these two conditions, the rule so framed would be void. So, there are two conditions. It must conform to the provisions of the statute and be within the scope and purview of the rulemaking power. Then, in the above said case, the rulemaking provision of the Cantonment Act of 1924 conferred power on the central government to make rules in the matter of the tenure of office, salaries and allowances, provident funds, pensions, gratuities, leave of absence and other conditions of service of servants or boards. In exercise of this power, the central government framed rules to make provision for transfer of the employees of the boards. It was held that the rule was in excess of the rule-making power given to the central government. The government, while framing rules under the Bihar Moneylenders Act 1938, fixed the upper limit for the loans which the moneylenders could lend through the Act, though the Act never provided for fixing of such upper limit. In Sansalan versus Parsuram Sahu, it was held that the rule-making power of the government does not extend to fixing of such limit, as it was not empowered by the Act. It is very common for the legislature to provide for a general rule-making power to carry out the purpose of the Act. When such a power is given, it may be permissible to find out the object of the enactment and then see if the rules framed satisfy the test of having been so framed as to fall within the scope of such general power conferred. If the rule-making power within the scope of such general power, if the rule-making power is not expressed in such a usual general form, then it shall have to be seen if the rules made are protected by the limits prescribed by the Parent Act. From the provisions of the Act, we cannot spell out any legislative intent delegating expressly or by necessary implication the power to enact any prohibition on the transfer of land. And then if your Lordship see, my Lord, towards the end of, my Lord, this page, towards, my Lord, just after placitum F, their Lordships opined that the right to carry on a business guaranteed under Article 19(1)(g) of the Constitution carried with it the right not to carry on business. It logically followed as a necessary corollary that the right to acquire, hold and dispose of property guaranteed to citizens under Article 19(1)(f) carried with it the right not to hold any property. And then, my Lord, paragraph 14, we are also of the opinion that a delegated power to legislate by making rules for carrying out the purposes of the Act is a general delegation without laying down any guidelines. It cannot be so exercised as to bring into existence substantive rights or obligations or disabilities not contemplated by the provisions of the Act itself. Well, this is ultimately the summation of all that the judgment has noticed. Now, my lords, this, my lord, also, my lord, this, my lord, judgment also, my lord, ultimately, when it talks about what is the substantive provision, how it must be, my lord, read and interpreted and understood, and how ultimately the rule-making power must be, my lord, relegated to the confines of, my lord, the substantive provisions of the statute, my lord, we come to the doctrine of expressio unius est, exclusio ulterius, my lord, which, my lord, says that, my lord, where the statutory language is plain and the meaning is clear, there is no scope for, my lord, doing anything beyond that. My lord, may I, my lord, in this regard, first, my lord, cite before your lordships, my lord, a judgment reported in 1989, Supplement Volume 2, 1980 Supplement, na? Give me a book. Supplement Volume 2, Supreme Court Cases, page 465. My lord, I'll straight away take your lordships to paragraph 16 of this judgment. This is, my lord, a rule of interpretation. Well, this is how the courts have read and understood it. We have already extracted Section 42 of the Act and Rule 18 of the rules. It would be clear that though Section 42 envisaged orders, preparation or confirmation of scheme and reparation separately, Rule 18 provides for limitation only in respect of an application under that section in a proceeding where an order was passed. There is the maxim, expressio unius est exclusio ulterius. Expression of one thing is the exclusion of another. Mention of one thing implies the exclusion of another. Where certain persons or things are specified in a law, an intention to exclude all others from its operation may be inferred. When mention has been made only of orders, the inference would be that preparation or confirmation of scheme and reparation are excluded. Again, my lord, the doctrine of interpretation is closer. The best interpretation is made from the context, etc. As we have seen, Section 1920 did not envisage passing of orders. My lord, I should not trouble your lordship with that. My lord, the principle of interpretation of these statutes, my lord, particularly when something is excluded, is to read it as excluded and not to, my lord, bring it in an inclusive manner within, my lord, the principal provisions of the statute. Sanjeev, that judgment that you showed me, is it on the doctrine?
Which paragraph? That order?
My lord, page 16, paragraph 16, my lord. Paragraph 16, if your lordships will please have a look. The maxim expressio unius est to exclusio ulterius, expression of one thing is the exclusion of another. Mention of one thing implies the exclusion of another. When certain persons or certain things are specified in a law, an intention to all others from its operation may be inferred. When mention has been made only of orders, the inference would be that preparation or confirmation of scheme and reparation are excluded. My lord, in our case, my lord, what I say is, my lord, when Section 19, my lord, confers an exclusive privilege only in the case of country liquor and, my lord, intoxicating drugs, my lord, it excludes, my lord, within the purview, my lord, IMFL. My lord, this is also, my lord, found resonance in, my lord, other judgments of the Supreme Court, 2003. To this, another judgment. Will your lordships continue, my lord, or should
We choose a date because it can't be finished, so in
my lord,
February. I think you would require another half an hour or so.
my lord, another, my lord, one session, my lord, should do it. I'm, my lord, trying to, my lord, make it as crisp and concise as possible. But, my lord, just give your lordship the doctrines and, my lord, the judgments. Well, I shall not, my lord, place all the judgments. I might give your lordship a few references and citations. So
You would need another 1 hour or?
Yes, my lord.
Mr. Banerjee, please.
I'll take.
No, you choose two consecutive dates in February.
May I
confer with Mr. Shah, subject to my lord's committee.
We fixed one matter.
February.
3 and 4, they're opening on 27th, so the first Monday, Tuesday.
Array, not like this. You remember one very heavy matter we have fixed 2 consecutive dates in February. Yes, so don't consult charts. Be from your recollection, you should say. It was on VC.
Thursday, Friday. That's all I say.
Sure. That's a heavy, that is 6 and 3 is exclusive zone days.
তুমি থার্ড ফোর্থ বলছো ঠিক আছে
Okay. My lord, subject to my lord's pleasure, 3rd and 4th of February.
3rd and 4th.
Very cold, Mr. Chairman. It's no colder than now because the peak you're missing is emerging.
Only on the wane.
On the way, on the way. No tweet jackets.
If it could be the following week, 10th and 11th.
My lord, 10th and 11th?
Yes, Manoj. Yes.
10th and 11th. Grateful. We'll take only one session.
Matters will always be there, but you have to give precedence. Passover matters, take this matter, all matters will, we will never find a blank list.
Hello, your lordships will not be taking this up post lunch minutes, so.
If you want, we can. It's up to you. If it can be finished. Otherwise, there is no use. It's a wasted effort.
Very well, my lord, we shall come.
10th and 11th.
Please take down. Mr. Shah, learned senior advocate,
Over to you.
continues with his argument, but does not conclude the same.
Sorry,
Full stop.
I will not do it to you every time.
Learned counsel for the parties.
I'll just keep the exercise book.
These appeals are specially fixed.
My lord, petition, my lord, not appeal.
Yes, yes. This writ petition is specially fixed. On 10th and 11th of February.
My lord.
Same matter, same order in both the matters. There is another matter.
Yes. To hear further arguments.
Yes.